Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode. From the latest rulings in the courtroom to the strategies unfolding in the boardroom, and from real conversations taking place on the front lines to spotlighting what similar companies are doing about the challenges they face. This Week at Work brings you the conversations that matter most to HR professionals and business leaders like you. Brought to you by AIM Employers Association and Ogletree Deacons, live every Thursday morning. This is your opportunity to connect with their experts and ask your burning questions. So what's keeping you up at night? Let's face it together now on This Week at Work.
All right, welcome back, everyone. Good morning, Bert Garland. How are you today?
I'm doing well, Phil. How are you today?
I'm doing good. This is a really exciting time of the year, actually. Not just the extreme weather that we've had in the Midwest over the last 10 days or so, but there's a lot of things happening with football, the NFL. I love the college football format. It's inauguration season. That's exciting. Once every 4 or 8 years we experience that, and I think that brings a lot of good information. But there is a lot of crazy things going on. Have you heard about this thing with this guy right here, the Philadelphia Eagles fan?
I have heard about it. I watched the clip of the Philadelphia Eagles fan. He was
Okay.
he's definitely catching some heat while berating and name calling a Packers fan during a game, or
Right.
catching heat for doing that.
Right. So for our listeners, if they have not seen this on YouTube or wherever you would run into it, you have what appears to be, an Eagles fan, and Eagles fans are known to be kind of vulgar and aggressive fans. They take a lot of pride in that, in the city of brotherly love. And he is yelling at a lady. And calling her names and being pretty aggressive. But I'll tell you, I mean, I've seen it happen before: Blues games, Blackhawks games, Blues Detroit, in my lifetime. Where it even comes to people fighting in the stands. But nevertheless, today where it's a different age. And so this guy gets videotaped in his own personal time, yelling, mean and vulgar statements. I'm not condemning them in any way. I'm just saying what he did. And then his employer, I'm gonna guess, started to receive some negative feedback and had to jump into the picture, and that's why we're talking about it today. Um, can imagine this is the type of thing someone is going to call you for, Bert. Not they're probably not calling me on this one to say, how do we handle this? Um, and then I guess the employer eventually fires the employee after investigating it. I'd like to just kind of get your take on it, Bert. How do you lean in this space?
Yeah, I think that, first of all, we're talking about a private employer here. So we're not talking about First Amendment rights or anything like that. So, to the extent that this employee's off duty behavior put the employer in a negative light, the employer really can lawfully terminate the employment of this individual, so long as they're not doing it for a protected reason, such as protected concerted activity under the National Labor Relations Act, or terminating him because of his age, national origin, religion, gender,
All of those things, right?
disability, etc. Yeah, as long as they're not terminating him for an improper reason like that, he really is without protection. Again, to the extent his off duty conduct cast the company in a negative light and brought unwanted attention and unwanted criticism of the employer, lawfully they could terminate him. And I am aware that they did in fact terminate him. I kind of reading between the lines of the statement. I don't know if we have that the statement that the company issued after termination, but if you read between the lines of that statement, it appears to me that there was probably a severance agreement involved. The companies mentioned that no one should be remembered for their conduct on their worst day, and this individual is not a horrible
I
person,
thought it
and they're
was a
trying to
very well
support him.
written statement. It says at the same time, again, it is to be true to our values. We can condemn the actions without condemning the individual. None of us deserve to be remembered for our actions taken on our worst day. Thank goodness. Most people don't know my worst day actions. But yeah, that's well said. But it looks like there was a severance versus a straight out termination. Is that where you're getting to?
That would be my guess, but that's
Yeah.
speculation, just kind of reading between the lines. But I think the company did what they felt they needed to do to protect their image and their reputation, which is a valid reason for terminating somebody's employment. And it's a reminder to everybody that in this age of social media and everybody with cell phone cameras, you just got to be careful out there. You got to be careful and govern your behavior accordingly.
Yeah, I think that's true. Now, just for anyone not to be confused, there is a line that you mentioned that between this and what we've talked about on our program many times, where people are wearing buttons, stickers, hats, and they're maybe wearing it on company paraphernalia. I'm thinking about Home Depot, and there would be union buttons and or political buttons, and sometimes those activities have aligned with concerted activity. And in this case, there was nothing related to concerted activity and nothing related to any of the protected class activities. This was just off-duty behavior that reflected negatively on the employer. And as a private employer, they have every right to do whatever they choose.
I think that's a largely fair statement, Phil. Again, yeah, not protected concerted activity here under the National Labor Relations Act. He wasn't engaged in conduct with another person related to his terms and conditions of employment. And so, yeah, it's
Yeah.
definitely not protected concerted activity.
Well, I know now next time I go to the St. Louis Blues Chicago game, I'm going to gently just offer, can I help you and assist you as a Blackhawks fan? But they probably need that anyway. Their team isn't very good this year. Anyway, okay, so we'll move on. All right, Bert, you ready for Lawyer on the Clock?
I'm ready, Phil.
Okay, Nick, pull that lever.
Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, we've talked a lot on our program in recent months about the Fair Labor Standards Act and exemptions under the Act when we were talking especially about the salary threshold being raised under the Biden administration, which, of course, has now been overturned by the courts. But we did get into some discussions about the exemptions under the Fair Labor Standards Act. Just yesterday, the U.S. Supreme Court, in a rare unanimous decision these days, in a decision authored by Brett Kavanaugh, the court said that cases analyzed under the Fair Labor Standards Act relating to exemptions do not get reviewed by the courts under a heightened evidentiary standard known as clear and convincing evidence. Instead, the lower preponderance of the evidence standard applies. And so what that means is that preponderance of the evidence really is just, it's more likely true than not true. And so clear and convincing is something greater than that. Clear and convincing is a heightened evidentiary standard used by the court system, and it creates a higher burden for an employer to establish that somebody is either exempt or non-exempt in cases. And so
that's a big decision, and for it to be unanimous.
Yeah, exactly. And so Kavanaugh said that the Supreme Court only deviates from the preponderance of the evidence standard in civil cases in only 3 scenarios. The first is when a statute has it specifically written in there. The second is when the Constitution requires it. And the third is under Supreme Court precedent, in which the government pursues drastic action against a person, such as taking away citizenship. And none of those scenarios presented itself here. And so the court is going to continue to review these cases under a preponderance of the evidence standard.
Okay. Yeah. Interesting. Very good one. All right.
Yeah. So interestingly, this case, though, just by way of background, the case was brought all the way back in 2017 by 3 sales representatives. And the district court judge there in Maryland found in 2021 that they did not qualify for the exemption and were entitled to overtime because they spent more than half of their time at chain stores where they stocked shelves and placed orders, but rarely made their own sales. And so this case that started back in 2017 is now finally in 2025 just resolved based on this evidentiary standard. So pretty interesting. These cases take a long time. I've talked before when we talked about the Chevron case, and I said I think we're in for 5 to 10 years of bumpy roads here under Looper Bright in getting rid of Chevron deference for the cases to work their way through the court system. And this just shows you how long some of these court cases take.
Yeah, that is a long time. I mean,
It
what,
is.
7, 8 years probably
Yes.
for that to come through. Absolutely.
Exactly. All right. So the next one I want to talk about, Phil, is yesterday or 2 days ago, the U.S. Department of Labor issued an opinion letter on FMLA. They don't issue these very often in recent years, but they did issue one just a couple days ago dealing with the substitution of paid sick leave under state law and running concurrently with leave under FMLA. And so this is one we've been kind of waiting for guidance from the Department
Okay,
of Labor.
so yeah, we got this going on right now in the state of Missouri, Illinois, many of our other states that we're serving. So we're listening carefully here in this guidance.
Yeah, and so what the FMLA's opinion letter said is that if the employee is entitled to leave under a state paid sick leave law, the employer may not require simultaneous exhaustion or substitution of the paid sick leave provided by the state. So it's not entirely dissimilar to a situation where an employee is entitled to receive income replacement under a state workers' compensation plan or a short-term disability plan. We cannot require them to use that paid time, or not really the time. We can't require them to use the income replacement that those plans provide, but we can still require them to take FMLA time. This one to me is a little bit different because it's saying we can't require them to substitute their FMLA leave with this paid sick leave under state law. So we're going to have to see how this one kind of is interpreted by the courts when it works its way in there. I need to do a little bit more analysis on this because the way it looks to me is that somebody could get their sick time under the state law and then get their FMLA time. So I want to look at this to make sure that the opinion letter really does say that people can, in effect, stack their leaves, but just be aware that this is out there.
So many of our listeners are listening for this word, run concurrently.
Yep.
And I think what I'm hearing you say is the guidance letter says they do not have the right to run concurrently. They would be separated.
Yeah, that's what I believe that this says. Like I said, it came out a couple days ago, and I want to go through this in more detail, but I just want to bring it to people's attention that if you're having an issue like this right now, we do need to take this into account.
Yeah, no, I think this would be really good to bring back up in the next week or two, Bert, because if that's the case, I know many of our employers have programs that do allow these to run concurrently within their policy in the way that they administer their leave absence management. And this would require some policy written changes, handbook notices, those types of things that may have already taken one path that need to now be reversed and taken in a different way.
Yeah, and just pulling a quote out of the opinion letter itself, it says, quote, because the substitution provision does not apply, neither the employee nor the employer may use the FMLA substitution provision to unilaterally require the concurrent use of employer-provided paid leave during the portion of the leave that is compensated by the state or local program. So that's state leave. And
Yeah.
so, so I want to do a little bit more digging on this one, but I do want to bring it to everyone's attention.
Even though, and here's where it's going to get tricky, and you don't even have to comment on this, but I can foresee where state leave says it can run concurrently, but the federal law, which will supersede any state law, in that case, I'm assuming will say it doesn't run concurrently, right? Because there are some state leave programs that allow it to run concurrently with FMLA. And then in this case, the now FMLA guidance is it does not run concurrently. We'll find out more. Stay tuned. Come back and listen to future episodes. We'll keep you up to date.
Absolutely. All right, one more for you, Phil. Just want to mention that anybody who's been watching any of the news channels the last few days, maybe you've seen some clips of the fiery confirmation hearings going on with Trump's cabinet picks. They've been interesting. It's a lot of political theater, in my opinion, because the representatives ask these questions that they know they're not going to get answers to. They ask these gotcha questions, and they cut the nominee off, and the nominees have been pretty aggressive in their responses. One nominee that has not yet had her confirmation hearing is Trump's pick for the Secretary of the Department of Labor. She's a Republican out of Oregon, Lori Chavez-DeRemer. She was or currently is a freshman member of the House. She just lost her reelection for that House seat. And so then Trump nominated her to become the Secretary of Labor. And this is one pick that I think the Democrats really, really like by Trump. And I think this is one that signals Trump's willingness to work with the unions moving forward. I don't think his administration is going to be anti-union. I've said on the program a few times, I don't think he's necessarily going to make it easier for employees to unionize, but I don't think he's going to make it harder for incumbent unions to stay in where they are, especially in the construction industry. Now, again, she's been nominated for the Secretary of Labor. That's different than the National Labor Relations Board. But I just think that this pick is really interesting. I think the unions like it, and I think the Democrats like it. So just keep your eye on this one. I think she'll sail through pretty easily.
All right. Well, I can tell you it has been great political theater so far. I get tired of listening to it after a while because it's all out of the same stuff. But sometimes it's a little embarrassing, just as your everyday citizen watching this. I'm like, come on, these are our top politicians' behavior. It's just ridiculous.
I agree with you on that one, Phil. I watch it and I think to myself, I cannot believe we as citizens are paying spending our tax dollars on this. It's pointless. I understand everybody's, they need to do their duties and everything, but it is just pointless, and what a waste of money.
Yeah, and the whole gotcha effort that seems to be the catchphrase right now for these hearings is just so silly. But let's move on and talk about something more productive.
Sure.
All right. So I'd like to get some feedback from our listeners on whether or not they believe their company would have separated our Eagles fan, or whether they would have taken a different course of action. What do you think your company culture would have been? We'll keep your name confidential. We'll keep your company confidential, of course, as we always do. But would like to just kind of get your feedback. But we do have some burning questions that came in. Nick, do we got our sound effect for that? And yeah, there we go. All right. So Bert, I like these burning questions, and I want to remind our listeners you can submit your burning question to us, and we'll do our best to try and get it up on air. But we have some that have been submitted I want to talk about. And the first one is called Under the Influence. Can we speak to them about our suspicion? And this one's not too unusual of a question, but it is a popular question for sure. So here's the question. We have a reasonable suspicion that an employee is coming into work intoxicated. We do have a DFWP. You know what that stands for, Bert?
What does that stand for, Phil?
I don't know. I was hoping you knew.
Let's see.
It's gonna be a drug something DFWP. Somebody can help me out.
Drug-free workplace.
Drug-free workplace policy.
There you go. Thanks, Nick. You know, when you're reading these and trying to think through responses at the same time, you're going to draw blanks here. So drug-free workplace policy. And we can send the employee for drug screening, but are we unable to speak with the employee regarding the suspicion that they might have an alcohol problem? Any advice? So I think in this one, there's a few points of interest to consider. I think the answer is yes, you can. You can talk to them about these things. There's nothing wrong with that. And we get into, in my world of employee relations and looking after the well-being of the employee and protecting the employer as well. There's a careful line. And, I want to be careful not to go down the road of ADA, but I also want to look after the best care for my employee as well. So I'd like to get some perspective from you, Bert, on that.
Yeah, so this is an interesting question. I'm going to focus on one word that was used in the question itself. So the question starts out, we have reasonable suspicion that employee is coming into work intoxicated. That in and of itself gives you reason to go to the employee, and frankly, you have a duty to go to the employee and confront them if they are intoxicated at work. They present a health and safety risk to themselves, to their coworkers, and possibly to the public at large if they happen to be driving during the workday for you, or if they are working on a product that if they assemble it incorrectly could create an injury for a consumer down the road. So just based on that alone, you as the employer have an obligation to talk to the employee about this. But the question goes on, and it uses the word here. It says, should we, or are we unable to speak with the employee regarding suspicion that they might have an alcohol problem?
That's where I was worried about ADA.
Yeah. So I think taking it to the level that they might have a problem is probably beyond the scope of the initial conversation. If the employee, in response to you confronting them, says that they have a problem, then you're definitely in the ADA realm. Now, even all of that being said, the ADA does not protect for current use when the employee does not necessarily come to you voluntarily to say that they have an alcohol problem. Instead, if they're showing up at work intoxicated, what you would want to do is confront the employee, send the employee for an alcohol test. If it's confirmed that current use of alcohol is not protected, only if the employee would come to you again and say, I have a problem, I need some help, I want to take advantage of the company's EAP program if we have one, then it's protected under the ADA. So very fine distinction here. I think, again, the employer has an absolute obligation to deal with this. I would not initially go to the employee and confront them about whether or not they have an alcohol problem. I would focus on the current suspicion of intoxication.
Yeah. And I would remind people that, I mean, this is why you do indicia training. And I know you and I have helped facilitate that. And there's programs available through AIM for that. But we want to make sure that we know how to identify impairment
Yep.
of all types beyond alcohol. And when we're approaching these types of scenarios, in the way I would have practiced these when I was in HR, is I would be looking for my signs of impairment. I would be doing that probably with a witness or someone who is also observing the same or different signals that I might be receiving. And I would then have and fulfill my duty to address the issue should I think that they are impaired at any level. But I may offer them, at that point, I'm going to determine, are they impaired? And if I think it's alcohol, and we can determine that through testing, we're going to test. And I may, at any point, offer the assistance of our medical programs, including EAP, without necessarily asking them the question of, do you have a problem? Is this been, an ongoing issue? I don't know. I don't want to get into that conversation. I think that's what you're saying, but we can still offer the assistance of our program and try to help the individual improve their scenario should they have a problem.
Yeah, I think what I'm suggesting, Phil, is that we don't want to enter into the situation where we are, quote unquote, perceiving the individual as having an alcohol problem. We want to focus on the current impairment or the current intoxication or suspicion of intoxication. If the conversation leads into that they have an alcohol problem, yes, we need to go down that road. But again, even the ADA does not protect somebody who's in the workplace currently under the influence if they have not come to you voluntarily to seek help for having an alcohol problem.
Absolutely. All right. You want to move on to another burning question?
Sure.
I got this one's an interesting one. It's called Milk and Miles. Milk and Miles, balancing breastfeeding and travel requirements. So this one also is not too uncommon, but I think in this scenario, it's a little bit more uncommon. And the question is, we have an employee currently breastfeeding her 1.5-year-old child, 1.5-year-old child. And she shared that she cannot travel for work due to breastfeeding. Her role requires her to travel as part of the job. In a situation like this, what are our options? Now, the first thing I would say is if the child's 1.5 years old and the role requires travel and now she can't travel, I mean, has she not had to travel in the last 1.5 years? So I would want to know that as part of answering this question. I don't know that in this scenario. So has she traveled before and now all of a sudden there's something unique about this particular travel situation that she isn't able to? But Bert, I'm going to throw it over to you and get some perspective.
Yeah. So, first of all, I think that there's a couple laws out there that were passed in the last couple years. There's the Pregnant Workers Fairness Act. There's also the Pump Act, which is the protecting the right to pump at work law. And, so I think the employer is squarely within those provisions. First of all, Phil, I'm glad you read the question, specified that the child was 1.5 years old. I didn't see the point in there. I first read it that she was breastfeeding her 15-year-old child. But again, I don't want to pass judgment here. But so a 1.5-year-old child. And, I think under the Pregnant Workers Fairness Act and under the Pump Act, we have a duty to engage in the interactive process with the employee to find out, first of all, if there's an actual prohibition by her medical or her healthcare provider that literally prohibits her from traveling for work. I've not heard of that. I believe that people can still travel while they're breastfeeding and that they can pump. And I think we have the right to engage in a reasonable accommodation discussion with her to see if there's something other than eliminating the travel. If that's an essential part of her job, we have to reasonably accommodate, and that might mean that we allow her time during traveling to pump and provide her maybe something for her to store the milk in while she's traveling, something like that. But as far as eliminating an essential function of the job, I don't think the employer is under an obligation to do that.
Yeah. And I think for me, there is that element of, has she not traveled in the last year and a half, right?
Yes.
And it could be that she's new to this particular role and it's required. There's lots of circumstances we don't necessarily know. but it is the interactive process. And I think here you're just trying to figure out, okay, what is the complication of travel? What's the length of travel would probably also make a difference too, right? Are you sending me away for a month? Are you sending me away for 2 days? That probably has something to do with it as well. So there's a few unknowns, but nevertheless, the interactive process, and then probably a little bit further guidance with someone at AIM or at Ogletree to help you navigate that if you're still unsure what to do.
Yeah, and let me just say the Pump Act, which again, it's the Providing Urgent Maternal Protections for Nursing Mothers Act. That law gives nursing employees the right to reasonable break time in a private place to pump breast milk at work. Interestingly, that law applies to most nursing employees for up to 1 year after the child's
Correct.
birth. And so
Yes.
this question says 1.5 years. So maybe we're not within the realm of the Pump Act, but I still think under the Pregnant Workers Fairness Act, we still have an obligation to engage in that interactive process with the employee. And like I said, I think the way to handle this one is to engage in a dialogue with the employee, find out if there's some other medical reason related to the breastfeeding that prevents her from traveling, and then to decide, can we reasonably accommodate or would it constitute an undue hardship? And we are not required under the law to remove essential functions of the position from the employee's job responsibilities.
Yeah, there you go. Well, there's our 2 burning questions for today. Again, I'll remind you, you can submit those. Producer Nick, how's that done through the program?
That is done. You can actually submit them in the same place that you do ask your regular questions, on the question mark icon to the right of the screen. And also, if you're watching LinkedIn or YouTube, we actually dropped a link in the comments as well too. There's a link that you can go direct to submit your questions as well, and we always have that QR code on the screen. So we all have multiple devices in our pockets and in our car and everything else. We can read a QR code somehow, right?
All right, you get it to us, and we'll do our best to address it and give you some guidance. Bert, I appreciate
Phil, and I will say the response has been overwhelming. I mean, the number of questions that we're getting flowing in from these various sources has really been quite amazing. We appreciate all the viewer participation on that.
Absolutely. I think they're fun, and some of them are very interesting as well. So we look forward to getting to more of those next week. As always, Bert, thank you for being a part of the program, and we'll be back next Thursday at 7:30 Central Time. Until then, you know what to do. Go be good to somebody. Bye-bye.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please like it, share it, and make sure it's on your calendar. If you're an on-demand viewer, don't forget you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.